Finally. Okay. Uncle Awe, good morning, sir. So that you're saying that you're waiting for me. How are you? Oh, God. Okay, so good morning, guys. Oh, sorry, good afternoon. Good afternoon, guys. How are you guys? Awe, how are you? I'm sorry now, I'm just about 4 minutes late. You won't already crucify me. Chill now. Just 4 minutes late. You are saying, since. I'm good, oh, I'm good, I'm fine. So, I guess I'm going to start the session now. But before I start, I want to get my Cama, my notes, my um, cup of drink, water. Okay, so I can remember last company law class where I discussed um, the the different types of companies that we have, as well as the private company, the public company. I told you those are the forms of company, and then the forms of companies are different from the types of companies. When we are talking about types of companies, we are talking about company limited by guarantee. A company must do to remain a private company. You know, I told you that according to section 44, it tells us that a company that is not a private company is a public company. If we look at the wordings of section 44, and then when you're looking at section 22, it tells us everything that we need to know about a public company, a private company rather. Then if you look at section 23 of the Cama, section 23(1) of Cama, it then tells us that if there is any event that the company in section 22 is in breach of any of those provisions, then the Cama can then change it from being a public company to being from being a private company to being a public company. So when you look at the provisions of section 23, it said subject to subsection 2. Now, when it says subsection 2 in section 23, it's meant to its own subsection. That is, it meant the subsection that starts with if a court on the application of the company or any other person interested. So let's go back to section 23, which says subject to subsection 2, where default is made in complying with any of the provisions of section 22 of this act in respect of a private company, the company shall cease to be entitled to the privileges and exemptions conferred on private companies by or under this act, and this act shall apply. So what basically that means is that when you default in anything in section 22, automatically you are regarded as a public company. Now the section 23 sub 2 now gives us grounds by which the court can look at your company and say, oh, if you can show before the court that such default was only accidental or due to inadvertence or to some other sufficient cause, or that on grounds that it is just and equitable to grant relief, then the court can deem it fit and then grant such relief. So I need you to understand section 22, section 23 and section 22 and how they work. But today we are going to be talking about capacities of a company, and I'm going to be talking about ultra buyers under company law, ultra vires under the Cama, under the common law rather. So capacity of a company. Now, when you're talking about capacity of a company under the Cama, the first place that you have to go to is section 27. Section 27, when you're saying capacity, you know that when I was teaching company law, when I was teaching what is a company, I told you that when a person or a group of people want to start up a company, that company becomes a separate legal entity from the people that are starting up the company. The company in itself can be sued without the members being sued. So I told you that if we have Tayo, we have Tunde, and we have Tolu, and Tayo, Tunde, and Tolu came together to form TTT Limited. For example, TTT Limited is by virtue of incorporation, as we are going to see in section 42 of the Act, by virtue of the fact that they have followed the procedure to incorporate TTT Limited. TTT Limited is separate from Tayo, Tunde, and Tolu. They are not the same anymore. They are two different entities. Do you understand? Now, because Tayo and Tolu is because TTT Limited is regarded as a person before the court, then the court, the only way TTT Limited can operate is through finances. How does TTT Limited get finances? By shares. Shares from both the incorporators of the firm, and then the corporators. The corporators are those people who later on corporators, yes. Corporators are those people who later on, buy shares from the company. If you were part of the people that signed the memorandum, you are an incorporator. But if you did not sign the memorandum and but you bought shares in the company, you are part of the corporators of the company. Do you understand? So the TTT Company Limited can only operate by shares. The shares can be gotten from the incorporators or the corporators, and it is that money that TTT Limited uses in financing its business. Now the next question is, how then do we determine the business of a company? The incorporators are the ones that would have stated the business of a company in its memorandum before they submit it to the company's to CAC. Do you understand? You must have stated it in your memo. Well, what is my authority for that? Let us look at section 27 of the Cama. When you get to section 27 of the Cama, what does it say? It tells us that the memorandum of association of every company shall state A, the name of the company, B, the registered office of the company, which shall be situated in Nigeria, and then C, the nature of the business of businesses which the company is authorized to carry on. The nature of business or businesses which the company is authorized to carry on. So it is only in section 27(1)(c). Section 27(1)(c) tells us it is a mandatory provision, and I told you that whatever is a mandatory provision, every company shall do it. If a company doesn't do it, then the company will face the brunt of the law regarding the not doing that particular provision. So now when you look at section 27(1), it says the memorandum of every association of every company, that the memorandum of association of every company shall, and I told you the word shall there tells us that it is mandatory, shall state. Now, and then according to section 27(1), it says two things actually. The first one is that it tells us that a company that is set up for the purpose of carrying on business, that is either companies limited by shares or unlimited company. Do you understand? But then if you read the latter part of it, he said, or if the company is not formed for the purpose of carrying on business, the nature of the object of which it is established, and that's a company limited by guarantee, which has been stated by virtue of section 26. Now when you look at section 26, it tells us that where a company is formed for the promotion of science, blah blah blah. I explained that in my previous video very well, so that you can understand. So if you don't understand how companies limited by guarantee works, please watch my previous video. You would see how companies limited by guarantee work in that video. So now we have two things: objects or businesses. Object or businesses. When your company is set up for the purpose of carrying business, you must write what those businesses that you want to do. You must write them down in your memo according to section 27(1)(c). But if your company wasn't set up for the purpose of businesses, then you should write down your objects. That's it's presumed that your company is a company limited by guarantee. Then you should write down your object in your memorandum. So statutorily, mandatorily, you are supposed to have your memorandum and write it down. Now let us go to section 40. I'm coming. Section 41. What section 41 of the Act says? Now, section 41 of the Act says that the Commission shall register the memorandum and articles unless, in its opinion, when you look at A, it says it doesn't comply with the provisions of this Act. Now, where you do not submit your memorandum of association, or if you submitted it but you did not state in your memorandum of association the business that is supposed to carry out, then according to section 41, the effect of non-compliance will be that the Commission will reject such registration. So it is mandatory that you put your business. If you don't put it there, then it would not be registered. Do you understand? And then if you look at B, the business which the company is to carry on, or the object which is to be formed, or any of them are illegal. So it then takes you further again. It tells you that when you are having when you're writing whatever it's you are putting down as your business or object in your memorandum, A says that you must have it down, but B now tells you that when you are going to write it down, make sure that you don't write something that is illegal down. That's what section 41(1)(b) of the Cama tells us. It tells us that we should not write anything that is illegal down, because when you do so, then there's going to be a problem, and you will not be able to register it. Now that we know that for a company to exist, you need to incorporate. For you to incorporate, according to section 27, it tells us you must have a memorandum, and inside your memorandum you must have your objects. 27(1)(c). Section 41(1)(a) now tells us that where you don't comply with the Act, then the Commission will not register. So these are the relevant provisions when it comes to capacity. Section 27(1)(c), and then section 41(1)(a), and then also section 42, because the effect of registration is that this particular company then becomes a separate thing, which means that these people cannot control this company anyhow again. For these people to be able to venture into anything, or for this company to be able to venture into anything, the company must make sure that the whatever it is doing has to be in line with the business or the object that has been stated in section 27(1)(c). If it is not in line with it, then it is ultra vires. If you don't do what has been stated in your object clause under your memorandum, whatever you do outside it becomes an ultra vires action. It then begs the question, what is ultra vires? I have made 2 videos on ultra vires, but for the purpose of this class, I will just peruse through the common law doctrine of ultra vires. Ultra vires is gotten from the word beyond power, which means that when you do something that you are not supposed to do, or something you have not been given express permission to do, then whatever you are doing is going to be beyond your power to do. So let us say that TTT, what is it called? Company was formed, also known as Tesla. I'm just giving an example, and we both know what Tesla is for. Tesla basically is for making electronic cars. They are manufacturing electronic cars. So according to the object clause of Tesla, or our own Nigerian version, which is TTT Limited, it was created for the purpose of manufacturing cars. Do you understand? Now, manufacturing cars was one of it. Then because we have an Igbo man as part of the corporators of the company, then we now have selling clothes. Selling clothes too is part of it, part of what the company is created for. And also we have a shipping container of crude oil, shipping container of crude oil. And because we have an Hausa man that is on the board, that's on this board, then we also have as part of what it was created to do, rearing and sales of meat, rearing animals and sales of meat, rearing animals, sales of meat. Because we have a Yoruba man, then he's also involved in agriculture and sales of agricultural produce. Now, just one company, they were starting up this company, and in the object of this company, what you can see is that it's manufacturing cars. At the same time, you can see that it is selling clothes. At the same time, you can see that it is shipping container of crude oil. At the same time, you can see that it is rearing animals and selling meat. At the same time, you can see that it is selling agricultural produce. And the question is, would you say that when it ventures into any of these things, or when it ventures into something incidental to it? So, for example, under this shipping of under this sales of manufacturing produce, he then decided to sell it to London. Well, according to what was written here, sales of agricultural produce is supposed to be sold in Nigeria, but he now decided to sell to London. Would we say that the contract of selling whatever it is to the London company is an ultra-vires act? Now, let us start from the beginning. How did ultra-vires start? Where did they start the doctrine and all that and all that? Now, when companies started initially, when in the common law, those olden England days and all that, when the company started, they usually used to have one or two, for every company, there's usually one or two things that company is created to do. Do you understand? And so there was the first rule that was stated in the case of Ashbury. I don't know if give me a minute, please. Yeah, Ashbury Railway Carriage versus Rich. In the case of Ashbury Railway Carriage versus Rich. Now, note that you should go to my other videos. There I stated the fact of all these cases, and I made sure that they are very comprehensive. Today's class is just to peruse through it and all that. I'm not going to be stating the fact and explaining the fact of all the cases. So the first place that we need to start from is Ashbury Railway Carriage versus Rich. Now, what was held in that case? The court held in that case that where you don't have a particular thing stated in your object, in your business clause or object clause, whatever it is called, in your memorandum, the place where you have your business written down is the business clause. Or for if you are a company of guarantee, limited by guarantee rather, the place where you have your object written down is your object clause. Do you understand? So where you don't have something written in your business clause or in your object clause, and you contract with a third party as regarding that thing, then that contract is void. Or you have done certain steps. Do you understand? You took certain steps in furtherance of something that is not written in your memo, under the business clause or object clause, then such steps that you took in furtherance of that thing not written down is also null and void. That was stated by the House of Lords in the case of Ashbury versus Ashbury Railway Carriage versus Rich. And also you can see the Nigerian case of Continental Chemist versus Ife Akando. Continental Chemist versus Ife Akando, where the company sponsored training of medical doctors abroad with contract that they will serve the company when they come back, and all that. Then the company then decided to establish hospitals and all that. The court held that establishing hospitals wasn't part of the object clause. The object clause there was to sponsor medical doctors outside the country, then all that. Now you are building an hospital and all that. It wasn't stated in the object clause of the company, and that you can find that in the case of Continental Chemist versus Ifiakando. Now, in the Ashbury's case, there is something very important to note. Now, when we are talking about ultra vires under this particular rule, it says that no matter what was done by the directors after such an act has been taken, the directors cannot rectify an act that is already ultra vires. Do you understand? Where the clause, the company, what's it called? The business clause of the company did not stipulate this thing. But then such act was carried out. Then subsequently, the directors came together to rectify such act. Rectification of such act is still void. It still makes the particular act done void. Do you understand? That was stated in the Ashbury's case. He said that you should note, though, that the difference, you should note that when we are talking about ultra vires cannot be rectified. It cannot be rectified by or ratified by the directors, because it was not stated in the first place. So when we are talking about these things, you need to look at these two cases. And also you need to look at the third case of AG versus Great Eastern Railway. AG versus Great Eastern Railway. Now, in this case of AG versus Great Eastern Railway, there was something known as the reasonably incidental rule. The reasonably incidental rule was stated in the case of AG versus Great Eastern Railway. Now, you know, the two cases that I mentioned earlier, the principles that were stated in the case, the two cases I mentioned earlier, the principles stated in the case were basically that where you do something that is not in your object clause, that is not expressly stated in your object clause, such act will be ultra vires. Do you understand? But now, in the case of AG versus Great Eastern Railway, the court then held that where something is reasonably incidental to what is stated in your object clause, then yes, the court will still hold it as part of the business that can be carried out by that particular court. So if you look at that case, the fact is that the company were authorized to construct railway, and it contracted with another company to supply rolling stock. It was argued that this was not explicitly provided for in the object clause. The court held that it wasn't a ultra vires transaction because it was reasonably incidental to the object of the company and would be allowed. Now, why would the court say this? This company was set up to what? To construct railway, and then the company then contracted to buy rolling stocks, you know, all those things on railway. I mean, how then will you construct railways when you can't buy the rolling stocks? Does it even make sense? So such a transaction to buy rolling stocks is definitely incidental to creating the company, to what the company can do. Do you understand? And that was the case of AG versus Great Eastern Railway. So the reasonably incidental rule was stated in that case. And also, let us now go to the next rule. Because of this reasonably incidental rule, you can trust lawyers. Lawyers now decided that when they are drafting the memo of a company, they are going to state a law just like this one. So let us apply the rule. The the rule that says that anything that is not written in your memorandum is ultra vires. It means that because I know that in the future, although what I want to do is making cars, this TTT business is created to do is to make cars, but because, you know, businessmen, they know that the fact that car business is selling today does not mean that crude oil business will not sell in the next 5 years. Do you understand? So they will just decide to write everything in their memo. Do you understand? And then because the court started seeing that people started writing a lot of things in their memo, the court then involved a new rule known as the main object clause rule. So what the court does is that the court will read all the object as a whole and look at the one that is more pronounced, or the court will look at the first one written on the self. You can have like 50 objects, but the court will look at the first one and then it will read every other thing in line with the first one. Where they do not correlate, it strikes down all those ones and hold the first one as the object clause of the company, or the business clause of the company. So if we were to apply the main object rule to this particular company, selling of clothes does not look like something that you can do when you are manufacturing cars. So therefore this one will be struck out. Shipping a container of crude oil does not look like something you would do. Rearing of animals, no. Agriculture, no. So if we were to apply the main object clause rule in this particular thing, we will strike down every other thing and just interpret this manufacturing of cars as the sole purpose why TTT was established. Do you understand? Don't forget that the first rule is anything not stated in your object or business clause will be struck down. Would be null and void if you should carry that act out. Anything that is not stated in your business clause. So because people heard, anything not stated in our business clause, let us start writing things down. Do you understand? And then we also have the reasonably incidental rule, which means that if you carry out act that is reasonably incidental to what we can have in your object clause, we can also apply that. Do you understand? It's also based on this reasonably incidental rule that people start writing a lot of things. So at least they can also argue that whatever they do will be reasonably incidental to whatever is in their object clause. So now the court then looked at it and say, this one that people are having 50 what's it called? 50 or more objects. It means that every company is going to be doing everything. So they then evolved the main object rule. The main object rule, which could be seen in the case of Cotman versus Braham. In the case of Cotman versus Braham, the court held that they will only interpret the main object clause independently, and then they will interpret it while they are looking at this, and if any of these does not align with this, they will strike this out to take only the first one, or the one that seems more pronounced in the whole of it. Do you understand? And then after that, lawyers will always find a way to circumvent the rule. They will always find a way to solve every problem that is becoming becoming a bone to their throat. And then you have the independent object clause. What is the independent object clause? When you are reading, when lawyers saw that, the court has said in the case of Ashbury's case, and also in the case of Continental Chemist versus Ife Akandu, the court held in both cases. Let me write them on the board so that I don't. Shit. So we have the first case of Ashbury Railway Carriage versus Rich, and also the case of Continental Chemist versus Ife Akandu. Now the court held in both cases that anything not stated in the object clause or business clause, same thing, object clause is ultra vires. Now, number two, then you now have the case of AG versus Eastern Railway Council. Eastern Railway, where the court held that anything that is reasonably incidental to the object clause will apply. Then number 3, we now have the main object clause rule. Yes, the main object clause rule is the case of Cotman and Braham. Cotman versus Braham. And in these cases, the court held that in the case of Cotman and Braham, the court held the main object clause, which means that it will pick the first one and then interpret everything in accordance with the first one. Then you have the 4th rule, which can be seen in the case of Cotman and Braham as well, and also in the case of Anglo Overseas Agencies Limited versus Green, where the court held the rule of the independent object clause. I think this was where I stopped, where I was teaching. So basically, when you are looking at all these rules, when you see the case of Ashbury Railway Carriage versus Rich, anything not stated in the object clause is ultra vires. Also in the case of Intercontinental Bank versus Avia Candle. When you are looking at the case of AG versus Eastern Railway Co. versus Great Eastern, there's a great here. AG versus Great Eastern Railway, the court held that anything that is reasonably incidental to what we can find in the object clause we apply. That's a reasonable incidental rule, where we had somebody who set up a company for making railways and then wanted to buy rolling stock. The court held that the sales of rolling stocks, buying and selling of rolling stocks, is reasonably incidental to making railways, obviously. Now, and then you have the case of Cotman versus Braham, where they interpreted the main object clause rule, where they tell you that we will pick the first one. When we pick the first one, we are going to interpret every other thing in line with the first one. If they do not fall with what we have, like the examples that I cleaned up from the board, where we have somebody who is manufacturing cars and all of a sudden the person is selling clothes and is selling food stuffs, they are not reasonably incidental, or we cannot also say that it's part of the main object of that particular company. And then we now have the independent object clause rule, which was stated both in the case of Cotman versus Braham and also in the case of Anglo Overseas Agencies versus Green. Now, in both cases, the court held that where there is an independent clause, after writing everything, like I stated here, after writing everything down, under it, you now write that it is the intention of the company that each of the clauses should be interpreted independently. That is the independent clause rule. The intention of the company that each of the objects should be interpreted independently. We can look at the dictum of Lord Wilbury in that particular case. That's in the case of Cotman versus Braham, where he also made that point. Now, we also have the subjective clause rule that was stated in the case of Bell House versus City World Properties. Number 5 is subjective clause rule. Oh, no, it's the case first. So we have the case of Bell House versus City World Properties. City World Properties. That's the subjective clause rule. Now, the court held, in this particular case, the court held that where the directors of the companies, when they can sit down, they will look at this particular act to be done, although it wasn't stated in the memorandum, or what they will write in the memorandum under the business clause. After they've written everything, oh, we want to buy a house, want to make cars, we want to be involved in crude oil, we want to do this, we want to do that, they will not put the independent clause rule, which means that every single clause here should be interpreted independently. That's number one. Number two, they now put the subjective clause rule, and any other thing that the directors of this company at any point in time sees as a business to be done for the good of this particular company would then suffice to be under the business clause. Do you understand? They make it it's called the subjective clause rule, where they say that the directors, they put it there as a clause, that the directors can do anything that they think fit that is going to be for the benefit of the company. Do you understand? The directors can do anything that they think fit that will be for the benefit of the company. That is known as the subjective clause rule. And that's the case of Bellhouse versus City Wall Properties. And also you have something similar in the case of Ray Introduction Limited. So I've been able to go through how many rules now? Five different rules that were evolved by the courts and their cases. These are the very, very important cases relating to this thing. Note that all these rules were evolved in England. Do you understand? But now in the UK, they don't even practice this thing anymore. Why do I say that? Because after the Jenkinson Commission, after the Jenkinson Committee in 1922 sat on the company law reform, they recommended the abolition of this object clause. After the Jenkinson Commission of 1962 sat, they recommended the abolition. And also, in 1972, when the UK joined the European Union, by virtue of Section 9 sub 1 of the European Communities Act 1972, in the whole of Europe, anybody that is under the EU have automatically abolished the object clause rule. That says that every company must have what they want to do in their object clause. It has automatically removed it. Now I am talking about companies. I'm talking about the common law rule in England. You know what? Everything that we stated here, were common law in the Ashbury versus Railway, whatever it is, were basically in the common law. This Nigerian case here followed the common law as at those times. Do you understand? But the question is, what is now obtainable in England now? In England, since they left, in England, since they joined the European Union, there are two things that caused them to abolish this object clause rule that says that you must write your business the business you will carry in your memorandum. There are two things. The Jenkinson Committee that sat in 1962, on the company law reforms, they said, no, I don't think this thing actually makes sense, let's remove it. That's number one. Then number two, the fact that they joined the European Union in 1972, and according to Section 9 sub 1 of the European Communities Act 1972, it says that the object clause is abolished. You don't need to have it for every country that is under the European Union. They don't need to have it anymore. So that's what is currently going on in England. Not just England. Let us look at other jurisdictions. Let us look at New Zealand, for example. In New Zealand, they've abolished the object clause as well. In Australia, Section 15 subsection 1 of the Australian Corporation Act as well abolishes the object clause, rather. And then also in Section 22 sub 1 of the Singaporean Company Amendment Act, it also abolishes this same clause that we are talking about. If we look at number 7 of the Sri Lankan Companies Act, it provides that company can engage in any lawful business whatsoever. Even if you look at Section 8 of the Companies Act, I think 1985 of England, it will tell you that you need to have your memorandum, but then the requirement of the object clause in the memorandum is no longer needed. So the next question we need to ask, all these object clause, in the first place, why did they say that they should be object clause? And then why did they then remove the object clause? Why did they say they should be object clause? Number one, so that investors, people who want to invest in a company, can know what exactly they are investing on. Do you understand? Like what Professor Goa will say, I want to paraphrase him in my own language. You don't expect that, oh, I will look at a company, for example, First Bank. If I want to invest in First Bank, let us say I have a 50 million that I'm not using again. If I have a 50 million that I'm not using again, and I want to, or I'm not using for the main time, let's say for 50 years, I mean for 5 years thereabout, I can just go to First Bank and say, you know what, is the deposit to get interest or something like that. If I know that I am putting my money in the bank, I know that I have to go through their memorandum to go and look at what exactly are the things that this First Bank can do. Do you understand? So for investors, it serves as a guarantee for people who are putting money in a particular company to know what exactly this company is going to use your money to do. And then for third parties that are contracting with companies, that's the second reason we have the ultra-vires rule. For third parties that are contracting with these companies, they have to know these companies, what were they incorporated for in the first place? What did they incorporate them for? Because if a company was incorporated for buying and selling of cars, or for manufacturing of cars like Innoson Motors, or Innoson is not manufacturing, Innoson is assembling of cars. But let's say Tesla, which is for manufacturing cars, or Innoson Motor, which was for assembling cars. And then all of a sudden you are hearing that Innoson Limited is buying and selling rice, and you want to sell rice to Innoson. I mean, when you want to contract with a company, you first have to go to the CAC. What does the memo of this company say? That's the first thing you have to ask. What is in the object clause of this company? Before you invest your money in a company, you need to go and look at what is in the object clause of this company. What does it say? It is such object clause that gives you notice. The third thing, the object clause of every company, because they are registered with the Cama, there is constructive notice on everybody as to what exactly this company is carrying out, as business or as its objects. There is constructive notice. If you did land law and equity, then you know what actual notice is. You know what implied notice is. And then you know what constructive notice is. Constructive notice is, if you have done due diligence, you should have found out this thing. So for example, if you want to buy land, due diligence says that you should go to the land registry and see whether or not that particular land has been registered. And if it has been registered, who registered? Is it the name of the person that wants to sell it to you? Or whose name is it registered? Do you understand? So if you do not check it and then you buy the land, and then later it was another person's name that was in the registry, then because that has been registered and it's a public document, there is constructive notice on you that you should have known. Therefore, if you are going to contract with a company to do business with that particular company, but you did not go to the CAC to go and look at the memo of that company to know what exactly is in the object clause of the company, then there is a constructive notice on you that you should have known. Do you understand? So those are the three reasons you need to have the object clause in in your memorandum. Then the next question: why then did they do away with the object clause? The next question is, why then did they do away with the object clause? Why did we say that we were not going to have the object clause again? Not also, I'm talking about England. Why did the English people say they were not going to have the object clause? We have New Zealand, we have Singapore, we have Sri Lanka, we have Sri Lanka, and we have what else? And Australia. Why did they say? Because when you are talking about the business world, the business world is such that Bitcoin is reigning now. Any coin can reign tomorrow. Do you understand? So the fact that one particular business is currently reigning now, I think Bitcoin, what else is trending? I can't remember. If you guys know what is trending, you can put it down in the comment section so that I can see it. But Bitcoin is currently trending right now. Any other thing can trend tomorrow. And then when it starts trending, what will happen to the company that had already started for Bitcoin? That already said, oh, I want to do Bitcoin. And then Bitcoin market is not crashing. Does that mean that company automatically crash? Can that company also have another thing to do? Do you understand? So business is such that it changes over time. Do you understand? There was a time where phones, if a company that wants to go into manufacturing of course phones like Apple, as at 1980, if they had it in their business clause to probably be selling books, would not, if they started manufacturing, if they start manufacturing phones, what that act would have been ultra virus. But when you have it in your business clause that this and this and this and these are the things that you want to do, then, but the approach that has been given by most of these countries is that you can do anything as a company. Just make sure that whatever you do is lawful. Now, if you look at Sierra Lincoln Act, it says that every company can engage in lawful businesses. So whatever you do as a company, just make sure that whatever you do is a lawful business. So that is basically the way that most of the companies, most of the countries perceive companies now. You don't need to be locked up into the object clause. That means you don't need to be locked up into what you say that is going to be you are going to do according to what your object clause. Do you understand? You can now do anything you want to do so far it is lawful. So basically, I have spoken about the capacity of companies under the Cama. Section 27 is extremely instrumental. When you're talking about section 27, it says that everybody must have their object clause in their memorandum of association. Section 41 says that such memorandum must be submitted, and when it has been submitted, the CAC can reject it on A, that's section 41A, where they have not complied with the act. And then if you go back to section 27, the mandatory provision that says that you shall put down your object clause. Although I am submitting personally that when it comes to the object clause, it should be a default provision instead of a mandatory provision. Do you understand? It should not be a mandatory provision that every company must. But let us say some companies are actually set up for the purpose of this thing, or an enabling provision, so they can write it in their memo that these are the things that they want to do. Bam, full stop. Anything that this company does outside this, then we know we don't come out hand for them. Do you understand? So if you, after we've submitted this thing with the CAC that it has been registered, all we want to do is just manufacture cars, and then you decide to buy a bag of rice from the company. I don't know where you saw that one in our object clause, but you decided to buy it. Now that is a company that decides to exercise an enabling provision in the act. I already explained to you what enabling provision is, what mandatory provision is, and what default provisions are. So make sure that you go back to my other videos if you don't understand what they mean. So make sure you go back to my other videos. But for this video, I'm telling you that I think that the object clause should either be a default or an enabling provision that says that if you decide to change it and then write it down, every company can engage in lawful business. That's what I am saying. Every company can engage in lawful business. But if you now decide that you want to restrict your company to only these businesses, then you can now put it down that, okay, I restrict my company to this and this and this. Do you understand? So after that, after looking at section 41, we then looked at section 42 that says that the moment you register your company, it becomes a body corporate that is different. And then we now try to interrogate under the common law, when you're talking about writing down your business clause, what does that mean? And what is the effect of what was the effect that the common law had? And then we looked at 5 different rules, starting for the first rule of the Ashbury Railway Corporation. In case you have any question, you can actually put it down in the comment section so that I will answer your questions before I end my live class. Please, in case you have any questions. Can you guys see me now? So in case you have any questions, please make sure that you put it down in the comment section so I will be able to see the questions. So yes, as I was saying, now then we now moved on to the rules that were evolved by the common law court, starting with the Ashbury Railway Council, where the court held that anything not stated in the memorandum of association will be declared null and void. If you do something that wasn't stated in the memorandum, we can hear you, but we can't see the board well. Oh, you can't see the board well. Okay. Can you see it better now? So, like I was saying, anything not stated in the memorandum of association or in the what's the Nigerian stand on it now on ultravirus? Well, that is going to be my next class for tomorrow. I told you that this particular class was supposed to be for just capacity. Capacity, now we know what capacity is. Then from capacity, we went to the common law doctrine of ultravirus. Then tomorrow morning, I'm going to talk about the Nigerian position rather on ultravirus doctrine. Do you understand? So tomorrow we'll talk about the Nigerian position on the ultravirus, and then after that we'll talk about whether or not companies can donate to political parties. Not just that, we'll also talk about the memorandum and articles of association and how to alter each of them. But this particular class today was to tell you about capacity and talk about the ultravirus under the common law. So, like I said, under the common law, you have 5 rules. The first one in Ashbury Railway Carriage versus Rich. The second one in AG versus Great Eastern Railway, where the court evolved the reasonably incidental rule. The third one in Cotman versus Braham, where the court evolved the main object clause rule. The other one, also in the case of Cotman versus Braham, and in the case of Anglo Overseas Agency Limited versus Green, where the court evolved the independent object clause, and also the case of Bell House versus City World Properties, where the court evolved the subjective clause rule. So I hope I have been able to talk about everything regarding capacity of a company and then the ultravirus doctrine. So if you have any question before I end the class, because I'm about to end the class right now. Do you have anything before I end the class? Timileyin, thank you. You are very, very welcome. Does anybody have any question before I end the class? Okay, so in the absence of any question, please make sure that you subscribe to my channel if this is your first time of coming on board. And also, if you have any questions to ask me whatsoever, you can put it in Sensei app. Sensei is spelled SENSEI. You can go to Play Store on Sensei app, make your way from the board. I want to take a screenshot. I feel like I see how they command me, but it's fine. So I hope this is fine. So you can send a message to Senti app, and I'll definitely reply you promptly as soon as you send it. And see you in tomorrow's class. Tomorrow's class, I'll be talking about ultravirus under the new Cama. And also, either tomorrow or the day after, I'll be talking about evidence law, admissions and confessions, as well as conveyancing law. 4 things to take note of before you enter into a formal contract to buy and sell land. So till then, I remain online, dear Kolola Daniels.